it's what you create out of that idea. It's your thoughts in some sort of a tangible form. You know, anybody can have the idea of let's say, a communication device, something that'll let one person talk to another. That's the idea. Nobody can own that, but what you can own is when you invent or create a phone, then you own this manifestation of that particular idea. The law has always recognized property rights. You know, going back to time immemorial, you always had a right to your real estate or to your home or to your things. You know, like you have property rights that you know that surround your your rights to your computer or your car or whatever. Property can be bought and sold. It can be pledged on loan. You know, we all know that if we've got a mortgage, right? The law of intellectual property has evolved around treating these intangible pieces of property, these manifestations of ideas, like regular property. So intellectual property assets, you know, they can be protected just like you can protect your home. They can be pledged on a loan. They can be sold. They can be licensed. You can do just about anything with intellectual property that you can with a real piece of tangible property, personal or real estate. Now, why is IP important, and what do we really need to understand about it? IP is important because, you know, we literally swim in it. It's everywhere. You can't go 10 minutes in your day without, you know, encountering some piece of intellectual property. You know, there are dozens and dozens of patents involved in an iPhone. I read once that there was something like 1,000 different patents involved in your average automobile, and that's before, you know, self-driving technology and everything that comes into play. So it's everywhere. You know, we're constantly bombarded by content on the internet or the radio or TV. That's all copyright. We can't go anywhere without encountering intellectual property, so we need to understand a little bit about it. Intellectual property, as far as, you know, as a business person is concerned, what intellectual property is important to you guys for is because it's what can give you a competitive advantage over other people. All right, it is, you know, essentially it can be your secret sauce, and the archetype example there is the formula for Coca-Cola. That's protected as a trade secret. It's viewed as a piece of intellectual property, and that's the thing that gives Coca-Cola an advantage over Pepsi and RC and everybody else. So intellectual property is important because it can be what sets you apart from other people, not only in terms of, let's say, like a formula for your Coca-Cola, but, you know, your trademark, the name of your business, the name of your products, and what sets you apart. Intellectual property can be a significant business asset, and that's incredibly important at the startup phase, where, you know, you're trying to get traction and get out into market, and what you're really relying on to get that traction is your potential. All right, so your potential can be bound up in intellectual property. You know, what do you have that somebody else doesn't have that will cause people to not only buy your product or your service or come to you for services, but entice investors? All right, these are assets that you have to view just like any other business asset, take steps to protect them and to take steps to leverage them. Intellectual property is also important from a defensive angle. What I mean there is you can look at existing intellectual property and determine whether or not somebody is already doing something that you intend to do, okay? And this is important, let's say, in terms of trademarks. You want to make sure before you adopt a trademark for a product or a service or even your company name that nobody else is already using it. So you have to look at things defensively.
Sorry, Mark. What happened with the rocket launch is it was originally named Rocket Hawk. And then for 3 weeks, we kind of started to set everything up. And then we got a letter from New York from a law firm saying, no. And then we said, okay, so what should be the name? And then as soon as we got the logo, name, everything together, we did the same thing what they did.
Right.
So from now on, we send a letter.
Yeah, but you know, you never know where these things are gonna come from, you know, here at Fort Myers in New York City, you know, it's two completely different markets, but, you know, you have to make sure you can use what you intend to use, and whether it's, you know, your business name or, you know, your technology, you have to make sure that you're able to use it. You should be cognizant of intellectual property because in the context of startups, you know, it's a best practice, right? You want to make sure that you know what you have, that you own what you have, and that you're protecting everything you have. Because as you get further down the line and you start asking people for money, that's one of the first things they're going to look at is what does this company have? Is it protected? Do they own it? Or are we just investing in something that anybody out there can do? So it's important in that respect. And also, you know, we'll talk about the different types of intellectual property, but one thing to remember is that it all sort of overlaps, okay? There's, you know, there's different types of property, the IP that protect different aspects, sometimes of the same thing, okay? That in mind, you know, we've got four main types of intellectual property: trademark, copyright, patent, and trade secret. Those are the ones that we're going to talk about today. And each of these could be the subject of their own hour-plus lunch and learn. So I'm just going to try and hit some high points so you all know what these things are, what they relate to, and kind of why they're important to you as a startup or a growing company. So we'll start with trademarks. And these are probably the easiest to grasp because we run into them so often. Trademarks are, simply put, words, designs, sounds, and even colors that identify the source and origin of goods and services. They're the things that set you apart from other people. Okay, it's things like Nike, the name Nike, or it's the, you know, the 3 lines on an Adidas shoe. It's the color pink on Owens Corning fiberglass installation. You know, we all see the pink insulation. Everybody knows, yeah, that's Owens Corning. I've seen that before. Okay, those are the things that set you apart and differentiate you from your competitors. As far as trademarks are concerned, the first to use a trademark has the superior rights to that trademark. Okay, which is why, and you know, Peter can attest, you should search existing trademarks before you adopt something for your own purposes. Otherwise, you're going to get that nasty letter from a lawyer somewhere, and even worst case scenario is stare down a preliminary injunction saying cease and desist. So you want to take, you know, because the first user has the greatest rights, you've got to pay attention to what's out there and make sure that as you're growing and coming to market, you're not stepping on anybody's toes.
But it matters too, right? The domain that someone's operating in. That you
Well,
can
yeah, you look at a number of different things, you know.
Like I'm surprised by New York. I guess they did a national trademark and that's why they went after you. But otherwise, there's more localized, right?
What you have to look at, you have to look at the similarity of the trademarks. You have to look at the similarity of the goods and services. You also can look at things like geographic scope of use. But in all honesty, with the internet, everybody is instantly global, right? So geographic scope isn't as important as it was back in the days of, say, when you were thinking about setting up, you know, a horseshoe shop or something, okay? But all that kind of goes into the infringement mix, okay? As far as trademarks go, some are stronger than others, okay? The strongest trademarks are coin words like Xerox. You can have the broadest rights to something like Xerox. And at the other end of the spectrum, there's descriptive or generic terms like, you know, cloud software solutions. Nobody can own that, right? Anybody can use it if they're dealing with cloud software. So when you are thinking of trademarks and what you're going to call your company or your goods or your services, you know, not only should you search, okay, but think in terms of the strength of the trademark that you want to use, okay? If you're going to use something that's really, you know, descriptive of your business or your service or your product, you're not going to have really extensive protection. If you come up with something that's completely new and arbitrary, like Amazon. What does Amazon have to do with selling books or e-commerce? You're gonna have a broader scope of protection. Trademark rights accrue automatically, okay? We get what we call common law rights, but they can be generally narrow, okay? They can basically relate only to exactly what you're using a trademark for, and possibly to bring up your situation, be limited geographically. So if you just have, you get rights immediately on use, but you might be limited to where you're using that. And so then you could possibly coexist with somebody in New York or Washington State or whatever. Registration provides additional rights, and registration is important, okay? You can register at the federal level with the U.S. Patent and Trademark Office, and each of the 50 states has their own trademark registries. Now, you don't have to register in all 50 states, okay? The federal registration is gonna give you protection across the United States. But you may want to consider state registration, especially here in Florida, because one of the great things that Florida trademark law provides is that if somebody infringes a registered Florida trademark, that infringer might be liable for the trademark owner's legal fees, okay? And, so anytime you can get the bad guy to pay your lawyer's bill, everyone's happy. You're happy because you don't have to pay me, and I'm happy because I get paid, okay? The infringement, as far as infringement is concerned, the actual question of whether a trademark infringes something, it's a delicate kind of balance. You look at a lot of different factors, the similarity of the trademark, similarity of goods and services, all of those things. If there is infringement, what are your remedies, okay? And the most relevant and important from both the offensive and defensive side of the coin are the ability to prevent somebody from using a trademark further and to get their profits, okay? So if somebody infringes your trademark, you can get a court order saying you cannot use this trademark or anything similar to it ever again. Oh, and by the way, you owe me all the profits that you made selling goods or services under that trademark, all right? And so again, from the defensive side, why you want to search things is because you don't want to be exposed to something like that as a startup and get hit with a letter from a law firm or a preliminary injunction.
So the main difference between a trademark and a copyright is the trademark you can start using, identify with the trademark, you don't have to register it, and eventually if that you're not violating anyone else's trademarks, you can turn that into a copyright, or you can...
Well, trademark and copyright are we're going to talk here about copyrights next, and there are differences, but generally the biggest difference between trademark and copyright is that trademark is for words, slogans, designs, logos, all of those things, short and sweet, represents a product, represents a service, represents a company. Copyright, on the other hand, does not extend coverage to those short and sweet words, slogans, etc. Okay? You can't necessarily get a copyright for a product name, just that name alone. iPhone.
I think he might have been asked the common law trademark usage versus registered trademark usage, or were you specifically wondering about copyright versus trademark?
Yeah, I was wondering about copyright versus
Oh, okay.
trademark.
Okay, I wasn't sure.
Okay, so that's the biggest difference between copyright and trademark, and it essentially boils down to, what the two different regimes of law are intended to protect. Okay, now, trademark, it is intended to protect the first user of a trademark, to protect them and allow them to identify and distinguish their goods and services from another person, okay, or another company. That's the primary purpose of that. It was developed and regulated towards trade, okay, and your goods, your services. Branding, we all think of branding. That stems from the Old West, when people would actually brand their cows. That's my cow, right? That's my trademark, that's my product, that's my good,
Okay, and then like you were saying, then whether it's registered or not registered, there's a differentiation there too.
But a slight differentiation there, because registered trademark rights, you will have broader rights.
Okay,
Okay, you know, again, sometimes, the biggest difference between registered and unregistered trademark rights are the scope of coverage, okay, because it could be only geographic if you're unregistered versus nationwide if you have a federal registration. That's probably the biggest and most important difference.
In terms of trademark, if you have a company, say in Illinois or whatnot, and they haven't really been using they have one, maybe it's expired or whatever, but they have like first rights and whatnot, and you're starting up something under a similar name, potentially similar trademark, is it possible then to do a national registration of it if theirs is expired, but they still might be existent? Or if there's anything going on in the 50 states, are you not allowed to nationally register it? Which is it better just to?
Well, you know,
This is a hypothetical.
yeah,
I just wondered.
you know, trademark rights accrue on use, and they exist only as long as you're using the trademark, okay? Now, if this other company is out of business, okay, and their federal trademark registration or their Illinois registration is expired, and they're out of business, and you look it up on the Secretary of State website, and it shows, you know, XYZ Inc., you know, dissolved in 1997. Okay, that doesn't matter. They're dead, they're gone, that's abandoned, all right? Trickier situation is when that XYZ Inc. had a federal trademark registration for, let's say, their product, okay? And their product is exactly what you were gonna market, and you wanna call it the exact same thing they had. They called theirs. They let their trademark lapse and expire, so their federal rights have been abandoned. But they're still using it in the marketplace, so they have some common law rights to it, and they can stop you from using yours. And that's exactly what happened to Amazon. When Amazon was coming to market, I don't know if anybody remembers this, but Amazon came to market under Amazon.com and Amazon, and their initial business model was online retail of books. And there was a bookstore in Minneapolis called Amazon Books. And Amazon Books ultimately extracted a large sum of money from Amazon.com. But there was litigation involved, and Amazon.com, being hyped as it was as the first big e-commerce company, was on the verge of losing its name and losing its preliminary junction stage. So copyright, it covers original expressions in tangible form. You know, what does that mean? You know, the archetype here is, let's say, a novel, okay, your screenplay, a photograph, okay, a sculpture, a drawing, a painting, lyrics to a song, a sound recording, a television program, all of that stuff. It can also encompass computer software, okay, because software is an expression in code. So it can cover computer software. When you obtain a copyright, you have exclusive rights to use and copy and distribute your copyrighted work. All right, you have the right to exclude other people from using it without your permission. That's the most important right. They last a limited amount of time. They're not perpetual. So if something is in the name of an individual, it's the life of that individual plus 70 years. And if it's something done by an institution or a work made for hire, then it will last 120 years. And we had some, recently, well, about 10 years longer than that, Disney was instrumental in getting some changes. In fact, these very changes to the copyright law, because a lot of the early Mickey Mouse cartoons were falling into public domain. So they were able to get extensions of copyright term.
Do we anticipate them trying to do that again?
I wouldn't put it past Disney.
Yeah.
I got a question on the software copyright you mentioned. Would that pertain to specific coding or the overall process? Because as you know, people can program 24 ways to do the same thing.
Well, it would, in the copyright context, it would be limited to your expression, i.e. the exact code. Okay, so if you code one way to do something, and somebody else codes another way to do the same thing, they're not infringing your copyright. All right, just because the end result might be the same thing, you're stuck with your code. which is, you know, in the software context, and I said IP rights overlap. In the software context, you have to really think what you're going to do and how you're going to protect your software, because, you know, you can do it through copyright, but it might be a limited set of rights. And then later we'll talk about patent and trade secret protection for that. So
Does
they
it have
kind of,
to
they
be
overlap.
registered to be protected?
Excuse me?
Does it have to be registered to be protected?
You automatically incur a copyright in whatever you produce. As soon as you put it in a tangible form, you have rights to it, okay? But registration is advised because you need a registration to sue under the Copyright Act, okay? Also, having a registered copyright can give you access to more remedies under the Copyright Act, including what we call statutory damages and attorney's fees. Now, statutory damages, in any lawsuit, you have to prove that you were damaged and the amount of how you were damaged, how much you were damaged. It might be really difficult in the context of copyright. Chair over here. It might be really difficult in the context of copyright, especially if you're talking about startup companies where nobody has a real revenue stream or anything that they can rely on to say, well, gee, you ripped me off and I would have sold, you know, 1 million of these apps. Okay, so statutory damages allow a court to impose a damage fee based upon infringement. All you have to prove is that you had a registered trademark and it was copied. And the court can impose statutory damages. And in the context of intentional infringement, i.e. the other party knew you had some rights to it and they ripped you off anyway, those statutory damages can be up to $100,000 per copyright infringed. And the Copyright Act has a provision where the successful litigant may be able to obtain their attorney's fees from the other side. So that's a lot of incentive not to infringe. Or it's also a lot of incentive to have somebody pony up and settle if they're copying your stuff. So who owns a copyright? It's created automatically, okay? But who owns it? And generally, the person who creates the work owns it, okay? And it's obvious in the context of, say, an author, you know, Ernest Hemingway owned the copyright to all of his writings, all right? In the context of a business situation, you have to look at it a little bit more closely. And like I said, the general rule is the creator has rights, but there are a couple of exceptions. And one of them is the employer-employee exception. If you have an employee and your employee creates something that could be protected by copyright, it's presumed that that employee created it for the company. So then the company will own all copyright in that.
If the owner, employee, employer are the same person, so it's, well, not technically the same person, say the C Corp, you're the employee of the C Corp, who owns it in that case? Since technically you can employ yourself, you can be both an officer and an employee.
Well, then, you know, I'll talk about that in a second, but, you know, that you want the company to own it, okay? Ultimately, you want the company to own it.
So you can sell it off, is what you're saying.
Exactly. Exactly. So if you are all three things at once, then as an employee of the company, you would be presumed to have done that for your employer. And the company, whether it's a C or an S or an LLC, is going to own that copyright, okay? The second thing to consider, especially for startups, is contractors. Because, you know, more often than not, you're going to be working with independent contractors. Somebody's going to design your website, or somebody's going to write some code for you, or create a user manual, or something like that, okay? And you're just going to hire an independent contractor and say, get this done for me. Generally, that independent contractor will end up owning the copyright in whatever they create, unless you have a written agreement with them, explicitly conferring rights to you. Okay, so it's called a work made for hire agreement, and in that, the contractor affirmatively states that they're doing whatever work they're doing for the company, and that they assign and relinquish all their rights to the company. It's really important to have that in place with all independent contractors as soon as possible. Otherwise, they may end up owning your IP. And, you know, it happens a lot in the web design context. The web designers, there's no provision. The web designer ends up owning the copyright to the website, and they have passwords into into the servers, and you fail to make a payment or something, and they turn off your website. And that's within their rights because they own the copyright in it. One of the other things with the situation of, the corporation, employee, and stockholder situation is something to consider in the founder situation. A lot of companies, a lot of startups will start literally over a kitchen table or something like that. And one person will say, I've got a great idea for this, for this app. And another person will say, well, I can write that code. And another person says, well, I've got a marketing degree. I'll figure out what we call it and how we sell it. And that starts picking up a little traction and things getting a little bit more serious. So you say, hey, we should really form an LLC here. That LLC, upon creation, owns nothing, okay? So what you want to make sure is that your business organization gets assignments of rights from anybody who worked for it or was part of the founding before it came into existence. Otherwise, those people are going to still end up owning rights to whatever IP they created. In the context of founders, you can do it, as part of a capital contribution. You can just list that, so-and-so is contributing all of their rights, intellectual property rights and copyrights, blah, 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 and the company recognizes it as capital contribution. But the important thing there is that you got to make sure that the company owns the IP and not the individual creators, even if they end up being members of the LLC or shareholders in the company. Get it all in the company's name. We talked about the federal registration. There's no state registration for copyright, and you need a registration to bring an action under the Copyright Act. Infringement, just want to touch on this really quickly because there's a couple, one thing in particular I want to mention. Infringement can happen in two ways, essentially. One is direct copying. Somebody absolutely rips you off. They right-click and steal content from your website, okay? Or they steal your code or whatever. There's that. And then there's substantial similarity, right? And this could be in the situation like we talked about with the computer code. There's different ways to code things. How similar are two pieces of code, okay? If the registered code or the copyrighted code is one way, how similar is this other code? If they're using a completely different way to get the same result, maybe not an infringement. If it's all the same, but say there's a slight difference in one little thing, maybe they're infringing.
Does the uniqueness of the food have to?
Because
there's code that everyone knows how to do something.
And there's what that comes down to is protectable and non-protectable, and something that is not unique may not be protected.
Yeah.
Okay, just backdrop. You can have a copyright. None of us are involved in architecture or real estate, but you can have a copyright in architectural plans. All right, and your copyright in architectural plans will protect you against somebody making a substantially similar architectural plan. But you have to look at it, and there are some things that are just not, that are not unique, not protectable. A house has to have doors.
Right.
A house has to have bedrooms. A house has to have bathrooms. Now, if they're arranged in the identical manner, then maybe there's infringement. But you have to look at the entire mix. How unique is the code at issue, or the floor plan at issue, or the art at issue? You have to look at all of that stuff and weigh the two together. But the important thing that I want to mention is some people, I hear about it every now and then. Somebody says, well, if mine is 10% different than theirs, or mine is 30% different than theirs, then I'm not infringing. That's junk.
I've heard different arguments for it, like CSS, how a lot of that ends up being similar, that a lot of people say that, in terms of copyright, like they don't know that that's even protectable in terms of CSS, but then you have trade dress, like what does it look like, you know, when you're actually doing it? And then that's another
All
point of
overlaps, all overlaps. You
Yeah,
can have,
the
you can
copyright
have
will look
completely
at it, yeah,
different,
as
you can have
opposed to actual
completely
code.
different code, but the screen outputs look the same. Well, maybe you have copyright or trade dress in your screen output, okay? And they're infringing that by looking the same,
Even though the code's completely.
even though the code's completely different,
Wow.
okay? So again, these things all overlap, and you have to look at different pieces to see what's the best way to protect what you have and the best way to go after somebody for doing what they've done, okay? But again, with the infringement, there's no percentages. You have to look at everything all together and throw it all in a bucket. It's fact intensive. Two really quick points about copyright, especially for startups, and those are, first one's licenses. You know, we're all familiar with copyright and end user licenses. You know, we click on it every time Apple updates the iOS and all of that stuff. So licenses spell out the rights of a party to use certain copyrighted works or copyrighted content, okay? What you need to think of in terms of this is that when you're entering a license agreement, say you want to use a trademark, or you know, you're a copyright, you want to use somebody's code or something like that, you want to make sure that you can do what you want to do with whatever you're licensing, right? So if you're getting a piece of software and you're putting it into some sort of package and selling that off to third parties, you want to make sure that that license will pass through and that you have the right to do that. Or you might have to get a separate license to be able to pass that software off to somebody else. So from the licensee standpoint, make sure that you can do what you want to do under any license. And from the licensor standpoint, same thing. Make sure that you're restricting people from doing things that you don't want them to do. All right, so you spell out all of the rights to what a person can and can't do with the copyrighted content. Quickly, open source. Open source is a hour plus thing on its own, okay? But the important thing to remember about open source is that in some situations it might not be as good as it looks. All right, open source is subject to different licenses, and the different licenses have different provisions. You know, I don't know how many of you heard of copyleft. Okay, so if you take a piece of open source, depending on the license you got it under, what you do with that open source itself may become open source. So you could essentially take a piece of open source software to fix a bug or something in your program that you're going to sell off to third parties, but then all this becomes open source and you really don't have any rights then into what you created. So you have to, if you're entering into, you know, if you're looking at using open source, look closely at the license agreement, what you're going to use it for, and the impact of it. You know, I would suggest get an attorney on board and have them help you walk through it, because you can end up, you know, stepping in some pretty deep potholes with open source. And
What
it
is-
might just be cheaper to code it yourself.
What does it take for someone to actually get access to your code to determine whether or not you're using their code? Because I mean, I don't do open source, but I look at a lot of open source.
Well, you know, again, one of the things is, we'll talk about this too, is all intellectual property rights are self-policing. So if you own intellectual property, you have to police it yourself and make sure other people aren't using it.
Right.
So, you know, you might be able to sneak something past, let's say, but if somebody finds out what's going on, all right? And you also have obligations under the license agreement, right? You could be in breach of the license. How are they gonna find it out? You know, there's all kinds of different ways to look at code and programs and reverse engineer and all that stuff. Technologically, I can't tell you.
Yeah.
You know, but what I can tell you is that if you're in violation of that license, then this is what can happen.
Yeah, but I mean, if someone, because my code is put into in a private repository of some sort, so you can't look at my code unless someone has told me I have to let you look at my code.
Right.
And in order for that to happen, someone would have to have some kind of probable cause to say that you have, right? And is that how it works? Not that I'm looking to steal anyone's code.
Well, you know, I mean, when we're talking about the technology of code,
Yeah,
all right, you know, how you know, that's beyond me,
yeah,
okay?
yeah.
Yeah, you know, there is this access to the code and what somebody needs for you to give them access, but there's also what can somebody else do to just get access.
But of course, if you reverse engineer my code, my license says you're not allowed to reverse engineer my code.
Yeah,
You just wrote
exactly.
it in.
But at some point, wouldn't you just have to bring a lawsuit against them to get them to show you their code?
At some point, yeah, at some point it could turn into that somebody is going to file suit, either that, you know, you have infringed my code and this is how I can prove it, or, you know, you have violated our license agreement by reverse engineering my code. Or you have violated my copyright by reverse engineering my code. Okay? So at some point it might get to that, and then you have to look at the code and the similarities and how it was accessed and all that other stuff. Okay, but there's, you know, I mean,
It seems like it has to be some really special code in order to go to all that trouble.
yeah,
Yeah.
but keep it in mind. Yeah.
It sounds like it would be the same situation as when Apple, well, the government was going for Apple because they wanted that code, or they
A
wanted.
bit like that,
Yeah.
you know, but then again, you know, look, they found a way to do it without involving Apple. You know, so you know, if there's a way to do it, somebody's gonna do it, okay?
How common do people jump on the litigation aspect? Is it usually when they see that someone else has reaped benefits? Because I mean, a lot of people do takedown notices and stuff.
Well,
When
you
you're
know, there's a, you know, in any infringement context, you know, whether it's copyright, trademark, or patent, you know, you have to weigh the situation and consider, you know, what level of volume you're gonna apply to the situation.
Do some people wait until you've earned and then, in the hopes to then litigate and then get it? I mean, would they just sit back and wait?
Well, you know,
Otherwise, there's no damages to apply.
I know, right? Let's see what this
you know,
does.
there are patent trolls out there
So,
who don't even send out a cease and desist letter.
Right,
and
okay, that's what I
all of a
was
sudden you get a lawsuit.
Right.
Okay, there are copyright owners out there who will send an email and give you 10 days to enter some sort of a license, or they're gonna sue you. And then, you know, on the 11th day, they sue you. Right, so it all depends on the situation, you know.
Well, so the Amazon books in Minneapolis probably wouldn't have wanted to stop Amazon.com the day they were founded, right? They wanna let them get some traction and,
Well, you know, the other things go into consideration there, because then
Sure.
you've got statutes of limitations and matches and all that other kind of stuff.
Yeah.
But, you know, for the most part, you know, you have to look at the situation and what it is. Now, if it's something that's incredibly important to your business, it is the heart of your business, and somebody out there is gonna rip you off 100%, you're not gonna wait,
right.
okay? Now, if it's some, you know, I used to represent Cummins Engine Company, okay? And with Cummins, we used to do it all the time. You know, there's a small repair shop in central Indiana that has the big Cummins logo on their sign. Well, they can't do that unless they're an authorized repair facility, right? So you just send them a letter, say, take down the sign, guys. You're not gonna sue over, you know, a sign necessarily. So it all depends on what it is, or how fast you jump to litigation or not. Some things will help fuel that, like, you know, the question of recovery of attorney's fees. You know, under the Copyright Act, a successful litigant gets attorney's fees. If you have a knockdown case, why not?
Right.
Because then that also goes into the negotiation hopper. Patents, we'll talk really fast about patents, okay? You know, and patents, we all know that they relate to inventions, okay? And they give you an exclusive right to preclude others from using that invention, okay? You have certain rights that'll last 20 years. The cornerstone for patents is that whatever you're seeking to protect with patent has to be new, novel, and non-obvious. You know, it's got to be the better mousetrap. All right. You have to show that whatever you're claiming as an invention is not something that somebody else could have just figured out by looking at it long enough that this is something really unique. Patents can apply to all kinds of different things. You know, processes, compositions of matter. You can get a plant patent. You can also have machines, or what they call articles of manufacture, which is the stuff we make. Okay, all of that stuff is potentially protectable by patent. Software, also potentially protectable, although there's been real significant changes in the law over the last couple of years as to whether or not a given piece of software will be considered patent eligible. If you're in the software business and you think that your software might, you might want to seek a patent to protect your software, get with counsel who really understands software patenting, because it's a really difficult and changing area of the law right now.
Has it become harder or easier?
It's become infinitely harder.
Okay.
Okay, although just 2 weeks ago, there was a decision out of the Federal Circuit that affirmed patentability of a piece of software. So there's little cheeks in the armor every now and then, but basically, the Supreme Court came down about 2 years ago and said, software patents, forget about it.
The whole patent climate is just changing, it changed when we went from first to invent to first to file.
Mm-hmm.
So that was one thing, and now I've seen in the like manufacturing and hardware side of things, it's getting more and more difficult. For instance, if you have a patent A has some idea and patent B has a different idea, and you file a patent C that uses some of the aspects of this one and some of the aspects of this one that nobody has ever combined before, a lot of the patent examiners are saying, no, it's obvious if you look at those two patents that you could combine them in that way, even though nobody ever has.
Right.
And if you look at the history of some of these technologies, that's how a lot of the stuff, that's how invention occurred, with people looking at patents and figuring out new ways to combine them. And
Yeah,
they're not
you
allowing
can
that.
still do that, but the examiners in some instances are getting much more hard on that.
They are, yeah.
The whole question of patent eligibility in the first instance and obviousness has really changed. The American Invents Act, with that shift to first to file, has changed things. The ability to challenge patents, validity of patents in the Patent Trial and Appeal Board instead of having to file a lawsuit, that's changed things. So patent is something that's it's a really dynamic area of the law. It's very specialized. I'm not a registered patent attorney. I don't write patents. I know just enough about patent law to tell you to call somebody, okay? And I know people you can call, but that's where my expertise ends. Yeah.
Mark, when you're licensing technology, how secure or enforceable is it to have a provisional patent rather than an issued patent?
Okay, provisional patents basically are they give you a filing date and an extension of time.
It's a placeholder.
It's a placeholder. It doesn't really confer much right at all, okay?
It's only valid for 1 year.
Right. The patent application process, we'll talk about that really quick. There's two different types of patent applications. There's a provisional and there's what they call a utility patent. A provisional patent is something that you only minimally describe your invention. Okay, you have to give very basic information, nothing really intense. And that gives you a 1 year period of time to file a utility application. The utility application is probably something that everybody's more familiar with. It's much more detailed. You have to describe the invention, you have to have drawings of everything, and you have to disclose what you claim is new and novel, and you claiming as your invention. You have to disclose prior art. It goes back and forth with the patent office. You might have to limit language, change language. You might be staring down a situation where the patent office says, hey, this is not, this is obvious. Anybody could have put these two things together to come up with this. It can be a long, hard slog. It'll generally take about 3 or so years to get a patent of registration. And in that, that's where you need the patent attorneys who deal with the patent office and can really deal with some of the real nuances of patent application language and claims and everything like that. Once you get a registration, okay, then your rights are going to solidified. And they'll date back to the day you filed the application and they'll last 20 years from the filing date. Now, if you file a provisional patent application, you know, what the provisional patent application and the placeholding can do is that when you ultimately secure patent registration, it'll relate back to the date you filed your provisional, okay? So even though a provisional on its own doesn't do much, down the line, you're gonna have retroactive rights to it.
Which is more important now than it was when we had the first to invent system, because then you could go back to whatever date you recorded in your logbook that you came up with the idea. You can't do that
Exactly,
anymore, right?
exactly. Now it ties to the filing date.
Okay.
One of the other things about the A, B, and C situation, you know, once you get a patent, okay, you have the right to exclude other people from using your invention. You don't necessarily have the right to use your own invention. It's kind of a quirky thing. And this is the situation where, like you say, you have A, B, and C. You know, inventor takes part of this technology and comes up with an enhancement to it, okay? Just because inventor has a patent on his enhancement to this technology doesn't mean he can sell it in the market, okay? To do that, he would need the rights of the existing technology, okay? So in that sense, even though you have the right to exclude others from using your enhancement to somebody else's technology, you might not have the opportunity to use it yourself unless you get a license from that technology holder. It's really, you know, a strange little quirk on that. Infringement, again, you know, just in any context, infringement depends on, you know, what you're using and how it's being used. But essentially, if you're using patented matter without rights, you can be found in, you know, infringing. Patent infringement suits are extremely expensive to litigate. It can easily eclipse $1 million, you know, within months, because you're talking about complex situations, you're talking about, you know, experts and all of that stuff. So if you're
So Samsung and Apple suing each other back and forth, it's like hundreds of millions probably.
oh yeah, hundreds of millions, you know. Arthrex down in Naples has a running dispute with one of their competitors where for years they've been suing back and forth over essentially the same patents and the enhancements to the patents, you know. It just can go on and on and on, you know, but you're talking about billion-dollar markets, it starts making sense. But these cases can be very expensive to litigate, even if it's something that you wouldn't think is a very complex patent. The last,
Sorry, could you go back real quick?
oh yeah,
The licensing,
oh,
it's, I mean, at your discretion, you could license patent before it's issued, right? If you can get somebody that is willing to pay it.
you can license, well, you can license any technology once the technology is available to be
Okay.
licensed, okay? One of the things with patents, okay, when you file a patent application, your application is confidential, okay, until it's published, right? During that period of time before publication, all of the information regarding your invention is secret, and you can protect it as a trade secret. So while you're pending in that sense, you can then license it out.
But if somehow that secret gets out, and somebody else tries to do the same thing, you're at least protected by the date of your filing of your patent.
Yeah, ultimately you are, yes, yeah. And another thing with licensing is, you know, you can license for certain situations only. If you have something that's protected by a patent and you want to manufacture certain things yourself and control certain things yourself, you can exclude that stuff from a license. You can give somebody a license only to make certain products, or only to do it in certain parts of the world, or something like that. Licensing, you know, just spells out everybody's rights, you can limit rights, and you can write in remedies. The last main piece of intellectual property is trade secrets, and trade secrets can kind of touch on a little bit of everything, okay? A trade secret, at its most basic, is something that you have that provides you an economic advantage or economic value precisely because nobody else knows it. And you take steps to protect it, okay? Though that's what trade archetype trade secret is the formula Coca-Cola. You know, it allegedly exists, the entire formula allegedly exists only on one piece of paper, kept in one vault in Atlanta that's on guard 24 hours a day. And nobody knows all the ingredients to Coca-Cola. Some people know a little bit, some people know a little bit else, but nobody
You know, it's like
knows
Kung
the
Fu
whole thing.
Panda, you know, you saw it.
Yeah, yeah.
The sauce is, there is no sauce.
So that's the, you know, that's the archetype of a trade secret. And then that's been a trade secret protected and viewed as a trade secret for over 100 years now.
There's no time limit on that.
No, trade secrets, as long as you keep them secret, they're protectable. The minute you disclose it, you know, then the sheets are lifted and they're public domain.
How does this work with GRAS, generally recognized as safe food products? You get a trade secret. I have Dax and my trade secret and Coke. How do we know it's not?
Honestly, I can't answer that.
No, I'm just curious
Yeah.
how that works.
Yeah, I know, you
You guys got regulatory burdens you're supposed to have, and then
right,
you got
but
this top secret.
part of meeting that regulatory burden, you know, there's ways to keep information confidential while you're in front of the agency.
Okay, so that's what they
So-
would utilize.
So basically, you know, by statute or whatever, or executive order under the agency, whatever they ask you for will be kept in confidence, you know, unless certain things happen. All right?
Or if they don't want to.
Yeah, and that's, you know, I mean, that's all part and parcel of the, you know, FDA approval of drugs and things. They want to know what's in your drug, and the same thing with the patent process, you know, you have to tell them what's in the drug. You know, you don't have to tell them everything, but, you have to give them information that they want. It stays confidential and a trade secret while the patent is pending, you know, and while you're in front of the agency trying to get, you know, approvals.
It's just, it's weird to me because I don't think recipes can be copyrighted. I mean, the idea is, well, if you don't tell anyone, then no one will do it. But, you know, if someone were to drop into their vault, you know, like Tom Cruise style, and steal the secret formula and release it on the internet, because they've gone to these efforts, will people be banned from using it, or is it now just out there?
Well, then you're trying to put toothpaste back into the tube.
Yeah,
really.
okay. I was
You know,
because, as long as no one knows, you're protected. Okay.
Well, but, you know, so that's the thing, the reasonable steps to protect the information, okay? And, you know, you may never be able to prevent Tom Cruise from going in and getting the formula code, but as long as you're taking reasonable steps, okay, then, you know, you'll have this thing protected. And no matter what, you're gonna be able to go after Tom Cruise for disseminating this. Whether you can put the rest of the toothpaste back in the tube, who knows? But Tom Cruise could be liable for the diminution of value of the Coca-Cola brand because of what he did. And, you know, he's never gonna make a movie that's gonna earn him that money. But you know, you don't have to, you know, information doesn't have to rise to the level of the Coca-Cola secret formula to be protected as a trade secret. It's basically, it's anything that gives you the competitive advantage. That can include your marketing plans, it can include your customer lists, your prospect lists, it can include your software code, okay? A lot of people, you know, because you have to disclose your code to register it as copyright. Don't want to do that. Don't want people to see exactly what my code is. Because it's so difficult to get patent protection anymore for software code, maybe not going to go that route. So how do you protect your code? You don't let anybody know it outside your organization. You keep it tightly under wrap, and you control access to it through licensing agreements. All right, and you let people know that you have this common law copyright claim in the code itself. All right, and as a condition of allowing this other person to use the software for purposes of this license, they cannot reverse engineer, let third parties use it, et cetera, et cetera, et cetera. So they can't then, you know, break the code and disseminate it. Otherwise, it's a breach of the license agreement. So that, you know, that's how software code might be able to be best protected anymore without having to disclose things at the Copyright Office level.
So if I have a metal box that is part of my product, and I wanna keep a trade secret what the box is made of, that wouldn't help me if I ship that box to customers and they put it in a machine and discover what it's made of, and then they make them themselves. So that's something I would rather patent protect than try to
Yeah.
trade secret protect.
Right. Okay, so, you know, you have to look at
You
exactly
can't
what.
really
You
keep it
can't,
secret.
yeah, you can't prevent somebody else from making a metal box, okay? You may not be able to prevent them, you know, from using the same metals, okay? But maybe there's also, you know, let's say the way that you mix the metals or whatever your alloy process is, okay? That you might be able to protect, maybe as a patent as part of the manufacturing process.
So more of the process, not
Or
necessarily
it's
the
some-
actual end result. So the process is protected, not the end result.
Correct.
Well, and in this case, the type of metal used is very advantageous and no one else has done it, so we do try to protect it with.
You can, yeah, you can try to protect it that way, okay, you know, then there's also other things to consider with it as well. And the manufacturing process is one of them. If there's something about the manufacturing process, and maybe it's the metal you're using, okay? As
Yeah,
part
in
of
this
that
case
process,
it is the metal that you use because of the specific properties of the metal.
then that could be protected as part of the patent.
For
Maybe-
our application.
Maybe your patent claim is, you know, I claim, you know, the use of metal XYZ in the creation of blah, 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 blah.
Yeah, in the creation of this product.
Yeah, right. One recent development with trade secrets, I don't know how many of you heard about it, but, you know, like in the last 2 months or so, Obama signed the Defense of Trade Secret Act, which now gives federal level protection to trade secrets. They have been solely protected under state law. And so there was, you know, 50 different states with 50 different regimes of trade secret law. You know, while there was a lot of uniformity in the law, there were still some little differences, and this is going to help iron out some of the differences. It also gives the right to have an independent trade secret action in federal court now, because, you know, they were matters of state law. Unless you had other federal claims going on, you likely weren't going to be able to litigate a straight up trade secret theft case in federal court. You know, I mean, jurisdiction stuff aside, you know, it was difficult. The federal law now allows for seizures and even ex parte seizures, where you can go in and get stuff before somebody even knows you're coming. And what you can get could be product, if they've developed product, using your trade secrets. You can seize and quarantine their goods so they can't sell them. If you believe that they have stolen trade secrets, but they're not in the market yet, however, all of it is resident on their computer network, you may be able to seize their computers. Okay, it's something that's really new, and it's gonna have to be litigated to see how it plays out, but it's a really interesting provision to the federal law that wasn't available under state law. And the last thing, the important thing that the federal law provides is you have to give whistleblower protection notice. So when you have a non-disclosure agreement with an employee, and you're saying to the employee, you know, you cannot disclose our trade secrets, you know, for 3 years to competitors, blah, 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 all that kind of stuff. You also have to put in there a notice that, you know, essentially says, oh, by the way, none of this applies to a whistleblower situation. And you can disclose our trade secrets to legal authorities if there's a whistleblower situation. So you can rat us out if we're doing something wrong. And we can't, you know, we can't necessarily sue you for exposing our trade secrets to the federal government. Okay? Trade secrets, you know, you need to have reasonable efforts to protect secrecy. Okay, so, you know, Coca-Cola vault, whatever. important thing to remember as startups is always use non-disclosure agreements with everyone, with independent contractors, with key employees, with investors coming to kick the tires. Make everybody sign non-disclosure agreements.
There's a problem with that. Early stage startups, investors will not sign on disclosure.
It's, you know, it's then a weighing, okay? It's a weighing situation.
We told several, sometimes, you know, startups come up with it, and then we go to the investor, okay, so are you willing to, no, I don't think I want to see that.
It's a weighing situation. Then do you lift the sheets, you know, and hope for the best, or do you keep looking for money, you know? It's all about leverage, right?
What's the reasoning behind not signing those delivery agreements?
Because it's such an early stage that they just feel that, look, whatever you have, that's not something you want to keep, especially because there could be several others who came up with the same thing what you came up with, because it's such an early stage, you're not really
So
selling
they're
your product.
looking at the NDA as almost like a patent application.
Well, in that case, I cannot be with all these others because,
Right,
well,
it exposes
you
them
know,
to
they came up with the
liability.
same thing, per se.
Yeah,
So, and then there's litigation based on what behind the NDA was discussed.
Yeah, they don't even want to get into that situation to be litigated because of an NDA. Okay? Right, so
Especially if they're working with 3 or 4 or 5 companies in the same space.
that's what I'm saying.
Yeah.
There could be, because you are such an early stage, there could be a zillion others in the same thing, doing the same or very similar things, and then immediately you get that kind of issue that you could be litigated. Even if it's really a kind of a grayish area, but you still run the risk.
There's another situation that comes up, I've seen a lot, where you have technology that you try to license to a particular industry, and you wanna get an NDA signed by the customer, the potential licensee, and they say, well, I'm not gonna sign an NDA until you tell me more about what you have. It's like, well, I can't tell you more until someone wants to sign an NDA.
Chicken on the egg.
Yeah. And because they might have the very same thing going on in their R&D lab
That's
at
correct.
that point, so they don't.
Or
wanna
more than that,
limit themselves.
they wanna see what you've got without having to, you know, any restrictions, so that when you go home, they can make it.
Exactly, yeah.
That's the more likely.
I tried to license a tire design once. That's what I kept running into, is like nobody would even sign an NDA to talk to me unless I tell them, well, what does the design look like? Or describe it to them. It's like the minute I would tell them 2 words about the design, they would immediately know what it was.
Yeah.
So the whole thing just fell apart.
So that didn't work out, I assume.
I have a clause in NDA that I've been using for a little bit that allows for an opportunity of the signee or the potential licensee to get out of it if they're able to provide proof within, say, 10 days of, you know, prior knowledge of similar or
Well,
specifics.
right,
Some of
that's,
that applies, but
Yeah.
still, you're right, if they talk to the next person next week, then they have to disclose to that person that they can't work with that person because they signed mine.
yeah.
They still see that as limited.
Yeah. It's
So
too much,
it's still-
too much
yeah, it's
hassle.
still tricky.
So they just don't deal with it.
Mhm.
What's the jurisdiction for this limitation? Are there other more friendly jurisdictions or less friendly jurisdictions for this issue? I mean, given when you're in a common law country,
Yeah,
the
you
sky's the
know,
limit, right?
under the federal, I don't know if the federal act is really gonna change that much of what it is, so you'd have to look at, you know, state by state. Okay, and I can't tell you if one's more friendly than anyone else in this, no, I'm not gonna sign your NDA situation.
Well, either state by state, or federal versus state, or even internationally, one country versus another.
So but the bottom line, investors, especially funds, angel or venture funds, you have to have, I mean, you must have something really, really big deal if they are willing to do it, but then you have to prove that.
Well,
So,
correct me if I'm wrong, if you're at that point where you're wanting to talk with them seriously about that, you should have something fairly significant to offer at that point anyways.
yeah,
Which would
No
also
Right.
show
No
proof of
question.
concepts.
no
Right.
question.
Right. Limit access, okay, we always use the NDAs, and then even in, use the NDAs when you can, even then, inside your organization, protect things with passwords or encrypted. Let it out only on a need-to-know basis. You know, not everybody in the company has to know exactly what's going on with everything else. Okay, so you limit the access only to the people who need to know the information. Do that, and your trade secrets could potentially be protected, infinitely. Okay, they don't expire. Okay. Really quickly, and we touched on this just now. IP rights are territorial. Okay, each country has their own IP regime. And just because you have rights in the United States to something doesn't mean you automatically get rights to that same thing anywhere else in the world, okay? You have to consider, even at the initial startup stage, if you're going to be a global company, you have to consider what the impact of foreign intellectual property rights might be vis-a-vis your main products and your first markets. People should always keep China in mind, if for no reason than other to do things defensively there, okay, to make sure that you get some sort of registration before somebody else does. Once you file applications to register trademarks or patents in the United States, there's a limited window of time where you can go ahead and seek international protection based on your U.S. filings. In the context of trademarks, it's 6 months after you file a U.S. trademark. You have 6 months to file internationally, and then those international jurisdictions will relate back to the U.S. filing date. There's some real significant patent issues with regard to disclosure of inventions that you have to consider if patents are going to be important to your business model. In the United States, once you disclose your invention to the public, you generally have 1 year then to file some sort of patent application. Okay? That doesn't work that way in the rest of the world. In the rest of the world, almost all, the entire rest of the world, once you disclose your invention to the public, it's public. Unless you had some sort of patent application pending before disclosure. All right, so if you're going to be international in scope and you're going to be using patents to protect your intellectual property, you have to think about how things are going to be impacted vis-a-vis disclosure and your U.S. filing deadlines and things like that. And you need to start thinking about it from the beginning, and Tesla is a good example of that. Tesla, they started in early 2000s, and they filed an application to register Tesla trademark in the U.S. for cars, right? At the time, they were just, a small company, and they weren't, they maybe had investors, but they didn't have any cars, they were growing, they weren't paying attention to things, they were just trying to get to market. So they didn't pay attention to the rest of the world. And all of a sudden, boom, Tesla explodes, everybody wants a Tesla, especially in China. Well, back in like 2003, somebody registered Tesla for automobiles. So now all of a sudden, Tesla can't use the Tesla trademark for Tesla automobiles in China because somebody else had already registered that and had the ability then under the Chinese system to stop Tesla from using it. So what did Tesla do? They backed up the money truck, and that's all they could do in that situation. So you should think globally from the start if you're going to have global aspirations. It'll be cheaper in the long run.
Apple was just banned from selling the iPhone 6 and 6 Plus in Beijing because of a patent violation with the Chinese patent, which I'm sure was probably filed based on some leaked information from the iPhone before.
Right, and they just lost a trademark action for the use of iPhone on cell phone cases.
Mm-hmm.
Okay, so you gotta pay attention to the international markets, and especially China, because it's it's not quite the Wild West anymore, but it's awfully darn close, and certainly not friendly.
Wild East.
The Wild East, yeah.
Well, do we really have any protections internationally in countries like China? I mean,
Well,
they're gonna do what they're gonna do.
They're gonna do what they're gonna do.
Unless you have really deep pockets.
And
That's the two things.
so you protect it. You protect everything that you can here in the United States. You do what you can in the United States, and you do things like I didn't mention it, but once you have a trademark registration, you can record your trademark registration with U.S. Customs, and then U.S. Customs, if you know counterfeit goods are coming into the country, from China or wherever, you can alert customs, and customs will seize those goods at the port of entry. All right, so you can do things like that, you're not gonna stop them from making counterfeits, but maybe you can stop as many of them coming into the country as you can. And then you go after people who sell your counterfeit goods. And this comes to the next point, is that IP rights are self-enforcing, okay? They're self-policing. You have to watch your own rights. Nobody's gonna do it for you. You have to monitor the market, you have to see what's going on out there, you have to see who's using something similar to your trademark, you have to see if somebody is trying to, sell a piece of software that's awfully similar to something that your software does. You have to watch out for these things and then take action when you can. Because if you don't take action, you can, in some instances, be considered to have acquiesced and given up your rights, especially in the context of trademarks. If you let people use your trademark or infringe upon your trademark for long enough, courts are going to start viewing it as like, well, look, you don't care. You're not enforcing your trademark. We're not going to do it for you. So you have to watch the market and you have to take steps. So, I know I've been talking forever here, and I apologize for that, but there's lots of stuff, and like I said, each of these could be their own 1 hour plus topic. So what do we want to get out of this, if anything? Just remember that there's different types of IP protection, and they protect different things and different ways to protect different aspects, right? You can, computer software, you got copyright, you got patent, and you got trade secret available. How is the best thing to protect it? Okay, maybe not the code, but the look and feel of the visuals, the user interfaces, all that kind of stuff. What are you going to protect? You got to think about all that stuff, and maybe there's 2 different ways to come at it. You want to ensure that your company owns all the intellectual property. All right, so you get assignments from inventors, you get assignments from founders, you make sure you have work for hire agreements. Always maintain secrecy, so you use non-disclosure agreements, you limit access to information, register everything, okay? I know it sounds like a pain, and it is an expense, all right, but it's good insurance. A copyright registration, you can get for, I think it's $55 to file a copyright application online.
Is it when you register, like my code, if I wanted to copyright my code, do I just need to because the code changes? So am I registering it at a certain period of time, or is it covering?
Well, it's copyright, when you have copyright, okay, you have the right to make copies and derivatives, which are future changes.
Mm-hmm.
Okay, so you copyright your code as of today, and then if your code changes a little bit, that's a derivative of this initial code.
And it's still protected?
And then it still can be protected. Now, if you have a radical redesign, that's something completely different. Okay, but seek registration, trademarks, and copyrights when you can, and then if you've got something that's patent protectable, do it. Talk to a patent prosecution attorney and do it, because that could be one of the biggest assets of your company. You should think globally from the start. You don't want, everybody wants to be Tesla, but then you don't want to be Tesla. You don't want to get caught with your pants down in China, okay? So think globally from the beginning. And then the last thing is make sure you enforce your rights. Watch the market and go after the bad guys.
If you're creating a platform under a specific idea, what would that be under in terms of being able to stop people or do something radically similar, or?
Well,
I'm just curious.
You look at it from all the angles, okay? You can look at what your trademark, what you're gonna call this platform, okay? Having Facebook is certainly worth a lot more than MySpace, even though the platforms did about the same thing, social networking, right? Okay, so what are you gonna call it? Copyright the design, copyright the look and feel, okay? Think about how you're gonna protect your code and different things that are behind the platform. Maybe it's trade secret, okay? You have to think about everything like that. You're not gonna be able to stop somebody from creating a similar platform, but you can prevent them from creating one too much like yours. So you have to look at it from all the different angles.
Hey, Mark, you may have already talked about this, but what about service marks?
Service marks, trademarks and service marks are essentially interchangeable terms, okay? Trademarks technically relate only to goods, okay? Actual products, and that goes back to the old brand, right? Service marks relate to the names of services, okay? You can protect a service, okay? And the name of a service, as long as you're using that trademark to identify the service, right?
It's pretty much the same process as.
Same process, you have the same kind of application, the same, time frame, the same requirements to show use and everything like that. It's just what exactly does this thing cover.
Okay.
Okay. So there's really no fundamental difference between the two.
I'm currently looking to develop educational materials, and the manner in which I'm doing it, the design of it, how the pieces fit together is absolutely unique. Is that something that's protectable, and if I wouldn't know how to write for that, or is it something that people could potentially emulate?
Well, compilations, okay? You're talking about pieces. I don't know what kind of pieces.
Right. Yeah. In terms of the way that it's designed, the method that the things are put together, so it's not quite a compilation of those particular elements, but the manner in which they're
Packaged.
well packaged, and also the way that the system of learning works. Yeah.
There's a lot going on there.
Right.
There's a lot going on there.
But
But-
the look of it would be.
The look of it more so than.
Yeah,
The actual
but
written form.
one of the things, like I said, compilation, okay? Go back to the architectural plan, okay? There's only, a house has to have bedrooms, a house has to have bathrooms and doors and windows, okay? And you can't protect just that, but what you can protect is your particular arrangement and compilation of those elements into this design. So now if your thing is a compilation of existing things, then maybe you can protect it from that angle. Otherwise, we go back to this, the Facebook, MySpace thing, you have to look at it from all the other angles and what you're doing and what might work best for it.
I have a question about, this is sort of one aspect of protecting yourself once you have your idea, but what about the perhaps equally difficult task of finding out what's actually existing, so you're not stepping on someone else's toes? I guess that's the hard part. And where does say a patent attorney or a law firm help you in that search or definition?
Yeah,
We have that example of, we have A, we have B that's been applied for, and then we have someone doing A and B combined. Where does A, B, where do they stand?
As part of the patent process, a patent attorney would likely recommend that you undergo a patentability search, which will look exactly for that. We'll look for prior art and existing patents and technologies, and we'll see if whether or not what you propose to do is novel or obvious, okay? And whether or not what you propose to do could end up being in the situation where, this is great, but you can't do it unless you license somebody else's technology first, okay? So a patent attorney could help you with a patentability search on that aspect, okay? There's also what we call a landscape opinion, which is when you just take a broad technology and you look at what everybody else is doing, okay? And, let's say orthopedic screws, okay? You would do a landscape opinion and look at every patent out there relating to orthopedic screws and see what other people are doing and where you might be able to fill a hole, or what you're doing might be different from anybody else. So that's another thing. As far as, what I do a lot is trademark searching, which makes sure you don't get in a situation like Apple, or like Amazon did, or like Tesla did, okay? So I do a lot of that. Copyright stuff, it depends what you've got. There's rights clearances and things like that. That's more important in situations that if you're doing, written work or film or video or something like that. But, counsel can help with those things. And also, in the context of copyright, especially if you're talking multimedia, help you negotiate through the various licenses you might need to use a song or to use do something like that.
Yeah, I've been interesting, back in the nineties, I wanted to do a public access TV program on using the internet, various things. And they had this really draconian rule, whereas if there was anything that was, basically any webpage you had to show, you had to have all the possible stakeholders on the information being shown there sign off at the time.
Yeah.
It totally shut, I mean, people do this daily on YouTube, and no one goes around saying, oh, you're using, even for profit. And this was even a nonprofit context, and so I just said, well, forget it.
Yeah.
I can't, you're kidding me.
Yeah, sometimes you end up running into that, unfortunately. But, you know, there are, especially in multimedia, there's all kinds of different rights clauses and everything that you have to worry about.
No, sometimes it's a matter of the appetite of the owner of the station, or whoever's in charge. Some, you know, two different companies might approach that differently.
Yeah, it was cable public access, so whatever the law said applied to that.
Well, and it also depends on what you're doing and how, and you know, what you're doing with this other content, because we didn't even talk about it, but there's like this whole fair use exception to copyright.
Yeah, they weren't, effectively, they were drawing a very, very non-liberal interpretation of fair use.
Okay.
Because I talked to someone fair, they're like, well, no. I was like, okay, fine. Because I took a whole class to do it and everything.
This may require a more in-depth conversation, but we have a situation where we started a nonprofit here in the county about 14 years ago, and we have a new, one of the chambers decided they were going to start using our name without our permission, and we repeatedly had discussions with them about doing it. They started making changes, and then they went right back to it again. So we're trying to figure out, like, they started using the name, and then the group failed and disappeared, and so we let it go, and then they started back out and they started doing it again, and we repeatedly asked them, and they said, oh yeah, we'll do it, and then they started doing things, and then they go right back to it again. So I'm just wondering, how long of a time frame do we have to pursue this before?
It's, you know, it's a fact intense kind of thing, because if you know of an infringement and you wait too long, you can end up being essentially.
We've been in a situation where we haven't had to wanted to have a war with them because they're doing some
Right.
good things in the community, we just don't want them using our name.
Right.
So, I mean, we like the concept, we just don't want them using our name.
Right.
So,
Right. Well, I think that, you know, there's some specific facts going on there that you better talk about one-on-one.
okay,
Okay.
sounds good.
Yeah.
I'll get your card.
But suffice it to say, in any intellectual property infringement context, if you wait too long, you might
That's what I'm concerned about.
be.
That's implied consent, isn't it, after a while?
Yeah, acquiescence is the term.
Document history of attempts to ask them nicely or otherwise cease and desist, and you've shown due cause, that, you know, due diligence, that you've made those efforts. I think that'll still be worth it.
And on the flip side, that goes to the question of the other party's intent. Okay, because there's a big difference between just, you know, say negligent trademark infringement. You know, there's really no such thing, but you just, you know, come to market and you're using this name. We didn't know anybody else had it. Okay, versus, hey man, that's my name, and they continue to use it. And
Yeah.
they stop and they come
But
back.
the problem we've had there is that they have high turnover. You know, they have turnover on the board, they have turnover in their staff, and so nobody knows, you know, when it started. I know how it started. It started with an ex-board member that was, you know, annoying. So they decided to be spiteful, but it's not, you know, they don't understand that because they've had turnover. So, you know, I'd like to sit down and talk before I go to the president and say, you know,
Yeah,
I want
well,
to change.
yeah.
So we got a little hammer to hit them on the head with if they have to.
Right, give me a call and we can talk
Okay.
a little bit more. Okay.
Okay, good.
So there is no similar guideline concept like adverse possession in real estate, in terms of, it's a very similar concept.
No. What you end up having is, well, essentially, I guess you could look at it that way, because, you know, in the adverse possession in real estate means, you know, if you're using somebody else's, you know, land open and notoriously and all this other stuff, and for a number of years, you can obtain possession of that land and actually be the owner of that land, okay? In the context of let's say, trademark, okay? If you're using somebody's trademark and they're aware of it, and they do nothing about it, and they do nothing about it, and they do nothing about it, then it could be considered that their rights have abandoned. So not only can you use the trademark, but anybody else in the world. So it's not like you end up wresting ownership away from them. What you basically do is you turn their trademark generic.
Question about protectability or licensability of that say, I thought of a feature for Facebook, for example, or some other domain to acquire customers or increase their sales. How would one go about protecting that, or then looking to license it to them without letting out of the bag?
Again, with any sort of, nascent idea, your primary and greatest protection is non-disclosures, okay? And even though, to a company like Facebook, they're not gonna sign an NDA because they get things all the time. And, you see it all the time with, with media outlets, and the movie studios. Anything you give to us is free to use, because they're getting stuff all the time. So, it's, where do you go with that? And that, that's the business question. How do you build a better mousetrap, and how do you really get in front of them? I can tell you how to protect it when you're getting in front of them, but how do you get in front of them? That's your job.
All right, thank you much, Mark. If you went to the meetup site, you see that this is a series of lunch and learns sponsored by Henderson Franklin. So please take a look at it. All great topics. All startups should listen to all those topics, and it's going to go until December.
Right, and in about a month, our next topic is going to be business formations and what you should think about as a startup. And over the next few months, we're going to have some other great topics coming in, like employee relations stuff, immigration, talking about that, and all kinds of different things. We're very happy to be working with Rocket Lounge on this, and I think it's great for our tech community. So thanks a lot, guys.
Thank
All right,
you.
thank you, Mark.
So does Mr. Campbell
Actually, no. We're sort of
With a couple of
Yeah, first open, so I graduated.